The subcommittee will come to order without objection. The chair is authorized to declare recesses of the subcommittee at any time. Welcome to this morning's hearing on federal courts during the COVID-19 pandemic, best practices, opportunities for innovation, and lessons for the future. Before we begin, I would like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you would like to submit materials, please send them to the email address that has been previously distributed to your office, and we will circulate the materials to members and staff as quickly as we can. I also ask unanimous consent that the following items be entered into the record. A letter to Chairman Johnson and Ranking Member Roby from Bruce Stern, the President of the American Association for Justice, and the results of a study of a recent survey by the Federal Bar Association of its members on legal practice in the COVID-19 era. And without objection, so admitted, I'll now recognize myself for an opening statement. Welcome to the subcommittee's hearing on the federal courts during the COVID-19 pandemic, best practices, opportunities for innovation, and lessons for the future. For more than 70 years, Congress has provided that, quote, all courts of the United States shall be deemed to be always open, end quote. That congressional mandate and the deeper principles it embodies has been sorely tested by the pandemic sweeping across the country. The idea of open justice is fundamental in any constitutional democracy. The concept encompasses a range of meanings, but today I want to focus on three. First, open justice means that our courts must be open for business, able to not just receive complaints and motions, but also to hear arguments, hold trials, and issue decisions without the undue delay that can rob any ruling of its value. Second, open justice means that our courts must be open to the public because justice made in the dark isn't really justice at all. And third, open justice means that our courts must be safe and accessible to all. Our judiciary is decentralized by design and inclined towards incrementalism, so it is to their credit that our federal courts move relatively quickly to maintain their operations and protect health and safety in the face of the coronavirus. Judges and court administrators had to make tough decisions that probably saved lives. They closed courthouses, postponed trials, and held hearings by phone and video. One court even held the federal judiciary's first virtual bench trial. With their courtrooms closed, many judges opened their proceedings to the public through live video and audio. Even the Supreme Court, which has for decades been committed to closing itself off from the public, allowed live audio broadcasts of its arguments. But with 4 months of experience behind us, and the reality that we are still in only the first wave of the virus, it's become clear that the courts and Congress need to do much more if we want the courts to be truly open during this pandemic and after. It's also clear that we can do more to insulate the judiciary against future emergencies, whether that's a second or third wave or a future pandemic. There is an alarming backlog of motions and trials that, if not addressed, could effectively decide cases against parties who cannot afford to wait for a judgment. The judiciary's historical resistance to embracing available information technology options could force court personnel, litigants, and witnesses into unsafe courthouses to attend proceedings that could have been held remotely. The risk of infection could shut the public and the media out of live proceedings. That could have been held remotely. The risk of infection could shut the public and the media out of live proceedings, and the lack of publicity about alternatives could shut them out of remote proceedings. The Supreme Court might return to its practice of forcing people to wait in long lines to cycle through a tiny, packed courtroom. These threats to open justice will force the judiciary to make some uncomfortable choices. There is a powerful desire to get back to normal, but the courts will put people at risk if they simply try to revert to how they operated before the pandemic. Instead, the judiciary should meet this crisis by exploring how to make the court more open, more effective, and safer than ever before, both during the pandemic and beyond. It can start by following the increasingly well-worn path marked by many innovative state and federal judges. The coronavirus has led us all to ask, what kind of government are we? What kind of government should we be? And most importantly, what kind of government will we be? Our federal courts are no exception. I hope today's hearing will help us find answers that preserve justice, promote public confidence in the courts, and protect the rule of law. It is now my pleasure to recognize the ranking member of the subcommittee, the gentlewoman from Alabama, Ms. Roby, for her opening statement.
Thank you, Mr. Chairman. Good morning, and thank you to all of our witnesses for participating in today's hearing. I want to first express my deep condolences to all who have been impacted by the COVID-19 pandemic. Over 120,000 Americans have died from coronavirus, and many more continue to be infected. I and my family, we are praying for the families and loved ones of those who have lost their lives, and for anyone who's been impacted by this terrible virus. Turning to today's hearing, I want to thank Chairman Johnson for convening this hearing on a very timely and important topic, and I will say it's nice to be back in our committee hearing room. The entire federal government, including the judicial branch, has had to react and adapt to the health challenges posed by the deadly COVID-19 virus. In particular, the federal judiciary has had to close courthouses, halt jury trials, and suspend in-person proceedings, given social distancing guidelines and health concerns. But we know that COVID-19 has not affected each state, city, or jurisdiction the same. As federal, district, and appellate courts begin to consider how to safely reopen, we need to ensure the federal judiciary is prepared to assist courts across the country as they start planning how in-person proceedings will look like moving ahead. I look forward today to hearing about the work that the Judicial Conference and the Administrative Office of the U.S. Courts have done to help provide guidance to federal courts during this challenging time. Both the Judicial Conference and the Administrative Office of U.S. Courts play critical roles in supporting an efficient, effective, and productive federal judiciary. I also hope that today we have the opportunity to discuss how Congress can support the Administrative Office of Courts in their continuing response to the pandemic. I anticipate that some of our witnesses may discuss the use of permanent remote technology in the courtroom even after the country recovers from COVID-19. However, as I mentioned in my remarks last September at the subcommittee's hearing on judicial transparency, I have deep concerns about the use of cameras in the courtroom and that the live broadcast of court proceedings. As we consider the use of technology in the court, we need to ensure that the judiciary is fully prepared to utilize that technology, and adequate safeguards need to be in place. We also need to remember that some courts and jurisdictions may not be readily equipped with the technological capabilities required to participate in remote judicial proceedings. For example, parts of my district in Alabama are rural, and securing access to quality broadband can be a real challenge. So while we discuss the reopening of the judicial system, we need to consider the best practices of how courthouses can safely reopen under proper social distancing guidelines, so that the needed proceedings in our courts can continue. I look forward to hearing from all of our witnesses today, and I thank you for your time to testify this morning. Thank you, Mr. Chairman, and I yield back.
Thank you. We will now introduce our witnesses. To begin, I yield to the gentleman from Arizona, Mr. Stanton, who will introduce Judge Campbell.
Thank you very much, Mr. Chairman. It is my honor to introduce Judge David Campbell from the District of Arizona. Judge Campbell has been a United States District Court judge for the District of Arizona since 2003 and a senior judge since 2018. He currently chairs the Committee on Rules of Practice and Procedure for the U.S. Federal.
McCormick received her BA from Trinity College and her JD from New York University School of Law. Welcome, Judge. Judge Jeremy Fogel became the first executive director of the Berkeley Judicial Institute in 2018. Prior to his appointment at Berkeley, he served as director of the Federal Judicial Center, as a United States District Judge for the Northern District of California, and as a judge for the Santa Clara County Superior and Municipal Courts. He received his BA from Stanford University and his JD from Harvard Law School. Judge Fogel has received many accolades, including the President's Award for Outstanding Service to the California Judiciary from the California Judges Association, and recognition from the Santa Clara County Bar Association for exemplifying the highest standards of professionalism in the judiciary. Welcome, Judge Fogel. And last but not least, we have Melissa Wasser, or Ms. Wasser, I'm sorry. Melissa Wasser is a policy analyst at the Reporters Committee for Freedom of the Press. Prior to joining the Reporters Committee, she worked as a law fellow for the American Constitution Society and legal extern to the Ohio House Democratic Caucus in the Ohio House of Representatives. She is a former Human Rights Campaign McCleary Law Fellow and a recipient of the Michael E. Moritz Leadership Award in Law. Ms. Wasser received her BA from Youngstown State University and JD and MA in Public Policy and Management from the Ohio State University. Welcome. Before proceeding with testimony, I hereby remind the witnesses that all of your written and oral statements made to the subcommittee in connection with this hearing are subject to 18 U.S.C. Section 1001. Please note that your written statements will be offered into the record in its entirety. I ask that you summarize your testimony in 5 minutes, and to help you stay within that time, there's a timing light that I'm not sure is visible to you. If it is not visible to you, I will tap the gavel at when you have 30 seconds left, and when you have 10 seconds left, I'll tap it a little louder. Judge Campbell, you may begin.
Chairman Johnson, Ranking Member Roby, and members of the subcommittee, good morning, and thank you for inviting the judiciary to testify on how the federal courts are responding to the COVID-19 pandemic. I appear today on behalf of the Judicial Conference of the United States. Like other institutions, the operations of the federal judiciary have been seriously disrupted by the pandemic. I am pleased to report, however, that judges in district, bankruptcy, and appellate courts continue to hold hearings, issue decisions, and resolve cases. Jury trials and grand jury proceedings have been postponed in most districts, but other proceedings continue to the greatest extent possible through video and telephone conferencing. In February, the Administrative Office of the U.S. Courts established a COVID-19 task force to monitor the impact of the virus on court operations and provide guidance and resources to courts on emerging issues. A COVID-19 website was established on the judiciary's intranet which addresses pandemic-related information and resources on a wide range of relevant topics. Circuit and district courts use these resources to meet their local needs. On April 24th, the AO published recovery guidelines for phased reopening of the courts. These include gating criteria and a real-time dashboard courts can use to obtain information about conditions in their own communities. The AO also established an internet hub on its website to keep the public informed about court operations. And some 20,000 court employees are teleworking through the court's virtual private network. For the courts, reconvening of jury trials is a priority. Individual courts are developing jury procedures for their unique situations that seek to minimize health risks for all participants. On June 14th, a subgroup of the AO's task force provided a detailed and helpful report on conducting jury trials and convening grand juries during the pandemic. Many federal courts are also communicating with their state court counterparts to exchange relevant information and best practices. It is difficult to predict the extent of the case backlog that will result from the pandemic. Some delays will result from the fact that jury trials have been postponed and will require priority attention when they can resume. And of course, bankruptcy courts will likely see a surge in filings that will affect their caseloads. We very much appreciate the $7.5 million in supplemental appropriations you provided in the CARES Act to address immediate technology needs and increase costs in our probation and pretrial services programs. On April 28th, the Judicial Conference submitted a supplemental funding request for $36.6 million to address urgent needs such as enhanced cleaning of court facilities, health screening at courthouse entrances, technology infrastructure, costs associated with supervision of offenders released from prison early, and security costs. Attachment 1 to my written statement provides additional details on this request. The Judicial Conference also identified 17 legislative proposals to address immediate COVID-19 impacts and post-pandemic operations. We ask that you please consider these proposals carefully. They are summarized in attachment 2 to my written statement. Thank you for working with us to craft provisions in the CARES Act that made it possible to hold video and audio proceedings temporarily during the pandemic for many pretrial events in criminal cases. These provisions have worked well during the emergency and have allowed courts to continue processing criminal cases. The CARES Act also directs the Judicial Conference and the Supreme Court to consider whether various sets of rules should be amended to include emergency procedures. That work is already underway through the rules committees of the federal courts. Mr. Chairman, thank you for the opportunity to address these issues. I will do my best to respond to any questions.
Thank you, Judge Campbell. Judge Chief Justice McCormick, you may begin.
Opportunity to talk about how Michigan's judiciary has responded to the COVID-19 crisis. Let me first put our workload in context. Michigan has 242 trial courts that adjudicate almost 3 million cases each year. Our courthouses are high-density places. And also, unlike restaurants and salons, they are not places people generally have a choice about whether to visit. We had to figure out how to maintain access to justice and also keep the public and our court employees safe. Public trust is the only currency courts have. The rule of law is, after all, just a set of ideas that are only as good as our collective faith in them. And with a great majority of litigants unrepresented, we build that trust in our courtrooms by what we do and how we do it. In 3 months, we have changed more than in the past 3 decades. And now, seeing the benefits of innovation, we have a unique opportunity to create long-term and much-needed change for our justice system. This pandemic was not the disruption that any of us wanted, but it might be the disruption we needed to transform our judiciary into a more accessible, transparent, efficient, and customer-friendly branch of government. We had a bit of a head start in Michigan. Before the pandemic, our administrative team at the Supreme Court had invested in outfitting every courtroom in the state with a video conferencing system and every judge with a Zoom license. In mid-March, on a dime, our team moved our entire workforce to remote work. From home offices, kitchen tables, and basement rec rooms, our management analysts and information technology teams have been working overtime to provide policy advice, practical guidelines, and technical support to transition a statewide judiciary to virtual courtrooms. And Michigan's court system is not like the federal judiciary, with one funding source and one case management system. Our non-unified system of 242 courts has 160 different funding units, nearly 24 case management systems, and 560 different elected judges. Despite this Byzantine system, since April 1st, judges have held well over 50,000 Zoom hearings and are approaching 350,000 hours of online proceedings. And to maintain public access, these hearings are live streamed to YouTube. For easy public access to them, we built a virtual courtroom directory, which is a clickable map that allows people to watch any judge in the state. This directory has been used more than 25,000 times in the past month alone. One hearing in particular, which had high public interest, had over 8,000 viewers at one point. We also pioneered an online dispute resolution platform that allows residents to resolve disputes with or without a mediator on a phone, tablet, or a laptop instead of going to court. Our free MyResolve service will soon be available to every resident in the state. We also are pilot testing text messages to notify the public of court events and payments. Dentists do it, why not judges? Our online legal resource center, Michigan Legal Help, is helping 10,000 visitors each day. In addition to their regular toolkits, they have more than 30 COVID-19 related resources, with the most popular providing information regarding unemployment insurance. We have issued a series of emergency orders to guide and support the trial court's transformation in response to the crisis, removing barriers to remote proceedings and innovating new processes. For one example, we transformed how courts will handle the eviction backlog proceedings once moratoria end at the end of this month. Our order protects public health, rationalizes case processing, and connects litigants to the resources available to resolve these cases, including $60 million from the CARES Act. Thank you very much. Virtual courtrooms are making our judiciary more accessible to the public. Lawyers can appear in courts in faraway parts of the state, all in the same morning. Litigants can appear in court without having to miss work. I talked to a judge recently who had a criminal defendant take a plea in a misdemeanor in a break room from his job in a different state. He was grateful that he did not have to miss a day of work and grateful to be able to take responsibility and get on with his life. Litigants who have disabilities don't have to worry about figuring out how to make it to court. Transportation, parking, childcare, and job responsibilities are not barriers to remote proceeding participation. And it turns out Zoom is less intimidating for parties who appear without lawyers. At least this is what we have learned so far. There's something about the equalizing nature of all of the Zoom boxes being the same size that makes people feel more heard and more respected. Maybe it's just less intimidating. Looking to the future, we cannot retool old ways to get people back into courthouses where access to justice is an ongoing problem. Instead, we must focus our resources on bringing justice to people where they live and where they work. We must rebuild what we do from the ground up and create a 21st century justice system that is accessible, effective, transparent, efficient, and fair. By embracing innovation, collaboration, agility, and user-centric design, we will do just that. I look forward to answering any questions that you have, and thank you again for the opportunity to address you.
Thank you, Chief Justice McCormick. Next, Judge Fogel, you may begin.
Mr. Chairman, Ranking Member Roby, and members of the subcommittee, I'm honored to be here with you And I'm going to summarize my statement in three respects. This crisis that we're all dealing with has been devastating to so many people in so many ways. I think it's also important to recognize that it presents an opportunity. We've been forced, the judiciary, along with many other institutions, has been forced to do things differently. It's been forced to do things that it would not have contemplated had the crisis not occurred. And the result of it having done it is that there is an enormous amount of data. The experience that the federal courts have already had, the experience that the state courts have had, all of that has given us information about how these processes actually work, what's beneficial about them, what isn't beneficial about them, where the technical glitches are. And I think it would be a shame if we did not take advantage of that. And one of the things I'm going to suggest that the subcommittee consider is formalizing the idea of a study of this data so that we can look at it in a thoughtful and critical way. Judge Campbell is an old friend, and I have immense respect for the processes of the rules committees. I think in normal times it produces very well-considered and thoughtful work that avoids unintended consequences. But it also reflects a certain small c conservative nature that the federal judiciary has. And we're faced with a situation now where that typical approach is not quite as feasible as it normally is. And so we have to figure out a way to proceed with care and thoughtfulness and deliberation, but at the same time recognize that we're working with a very much shortened time frame because of the conditions that we're in and the backlog that's continuing to build up. And I think I want to pick up on a point that the Ranking Member Roby made at the beginning. There are several different dimensions of this problem. I described them in a meeting we had yesterday. They're vectors, they're forces that are at work. And one of them certainly is access. It's the idea that the public has a right to see what's going on, that people have to have the ability to get into court. And so the use of virtual technologies to increase access or provide access is an absolutely critical value, critical principle. Equally important is efficiency. We have to get the work done. And Chairman Johnson referred to that in his opening remarks, that the work has to be done in a timely way so that people don't wait forever for justice that can't wait. So the value of efficiency is very important. And finally, and I think this goes to Ranking Member Roby's point, there's this whole idea of the quality, the value, the core values of the judiciary. What really matters, people need to be heard, people need to be seen, people need to be respected. There are socioeconomic differences in terms of who can get virtual access to what kinds of proceedings. And it's something that the courts need to think about. How do you do this in a rural area? How do you do this in a place where people don't have internet access or it's not readily available to them? And what kinds of proceedings just really aren't that amenable to virtual justice? If you're sentencing to someone to prison for 20 years, do you really want to do it that way? How do you do a constitutional jury trial in a criminal case? All of this, to me, is a imperative that we study these issues, we think about them with care, and we not waste the opportunity that the current crisis has presented to us. So I think if I were to have a wish list, one would be that the committee, subcommittee recommend and authorize that type of study, far-reaching study of the many aspects of this problem. And secondly, that it do what it needs to do, and this echoes something Judge Campbell said, provide the legislative authorization to continue experimentation, to suspend rules that need to be suspended, or give the judiciary the leeway to continue the experimenting that it's doing. I agree with Chief Justice McCormick that I don't think we're ever going back to where we were before. I think that's, maybe some people would like that to happen. I think that's unlikely to happen. And we have to anticipate a new normal, and we have to build that new normal with the same kind of care and deliberation that we built the old normal. Thank you very much. It's been an honor to be with you, and I look forward to answering whatever questions you have with me.
Thank you. And last but not least, Ms. Wasser. Please begin.
Thank you, Chairman. Thank you, Chairman Johnson, Ranking Member Roby, and members of the subcommittee. Good morning. My name is Melissa Wasser, and I am a policy analyst with the Reporters Committee for Freedom of the Press, a nonprofit organization that has been defending the First Amendment rights of journalists since 1970. Again, thank you for giving me the opportunity to testify here today, and thank you for your leadership on increasing court access throughout the federal judiciary. Today in my statement, I will recommend that Congress provide support and guidance to broaden remote access, both in audio and video, to federal court proceedings, and ensure that these advances in transparency survive both in future crises and become a fixture of public access to judicial proceedings generally. The Reporters Committee has long championed the public's constitutional and common law rights of access to judicial records and proceedings. And we have been monitoring the response of federal courts around the country to the COVID-19 pandemic. As mentioned by the other witnesses, this pandemic has changed the daily operations of federal courts across the country as they strive to protect the health and safety of court employees, litigants, attorneys, members of the judiciary, and the public. But I would note that press and public access to judicial proceedings and court records is no less important during times of crisis. In response to the ongoing pandemic, many judicial proceedings, typically held in open court, have been held remotely. To facilitate public access to these proceedings, the Judicial Conference temporarily approved the use of teleconferencing to provide the press and public audio access to civil proceedings. Courts and judges across the country have relied on this guidance to provide remote access for the press and public, but have implemented the policy in different ways. The United States Supreme Court also approved public access, hearing 10 oral arguments by telephone in May 2020 for the first time in the court's history. And the public has demonstrated an abiding interest in these proceedings. Within a few hours of the Supreme Court hearing oral argument in 2 cases involving the president's tax returns on May 12th, SCOTUS blog reported that approximately 500,000 people tuned into the live stream oral arguments. As of yesterday, an estimated 1.9 million people have listened to at least one of the Supreme Court's recorded oral arguments online, compared to the 50 members of the public who normally make it into the courtroom. Similarly, many of the videos posted by the U.S. Court of Appeals for the Ninth Circuit, which regularly live stream video of its oral arguments even before the pandemic, have hundreds of viewers, enough to fill several courtrooms. The Reporters Committee urges Congress to consider legislation that would permit courts to permanently remove barriers for the broadcast or streaming of proceedings in the federal judiciary. Congress should enact legislation to ensure that all federal trial and appellate courts have sufficient funding to continue providing live audio and video access to all public proceedings beyond the pandemic, and that courts are able to enact revisions to any contrary policy, including the Judicial Conference's cameras in the courtroom policy. This would include passing H.R. 6017, the 21st Century Courts Act, which would require live audio and an online archive of Supreme Court oral arguments and opinion readings, along with all federal appellate proceedings. H.R. 5645, the Eyes on the Courts Act of 2020, requiring cameras in all Supreme Court and federal appellate court proceedings. And last but not least, H.R. 6642, the Court Access Amid the Pandemic Act, which would require any oral arguments in circuit courts and district courts be made public in real time via video teleconferencing and telephone conferencing, and be permanently archived on the internet. While Supreme Court justices have expressed concern in the past that live audio and video could potentially hurt the sanctity and tradition of the court, and that the Supreme Court is unique and need not follow trends with respect to public access in the lower courts, the recent demand for streaming of the court's oral arguments last month clearly shows that the American public wants to know about its tremendously important work. According to recently released polls, 83% of Americans supported regular live stream audio at the Supreme Court, with nearly 70% calling for all courts to allow cameras in the courtroom. Additionally, public notice of when remote proceedings will take place and how members of the public can observe them is crucial, we have noticed that courts have been inconsistent in this respect during the COVID-19 pandemic. Uniformity in the manner in which courts provide such public notice would help remove an obstacle for members of the press and public exercising their rights of access. So in sum, the Reporters Committee believes that increased public access to the nation's federal courts, including the Supreme Court, is on balance an important step to promote accountability, transparency, efficiency, and an informed electorate. I'd like to thank the subcommittee for including me in this very important conversation surrounding court access, and I look forward to answering any questions that you may have.
Thank you. I understand that we're having some problems with my microphone on the WebEx platform, and so we're going to take a pause to see if we can work that out. And I must apologize to everyone. I was pretty strict on the 30-second tapping at your 4 minutes and 30-second mark for you, Judge Campbell, and also for you, Judge Fogel. But I started slipping with Chief Justice McConnell, and I just totally failed with Ms. Wasser, so I apologize. I couldn't help myself. It was getting so good. So at this time, we'll take a brief recess so that we can fix our problem here. We will recess for briefly hearing is back, and we will now proceed under the 5-minute rule with questions. I will begin by recognizing myself for 5 minutes. Judge Fogel, Rule 1 of the Federal Rules of Civil Procedure establishes that the rules must be construed to secure the, quote, just, speedy, and inexpensive determination of every action and proceeding, end quote. How should those three values animate the federal judiciary's approach to using virtual technologies during the pandemic and beyond?
Thank you, Mr. Chairman. Rule 1 is the basis of everything else. That's the way it's always been interpreted. And all of the other federal rules need to emanate from those core values in Rule 1. So my personal view of this is that particularly during the pandemic, but hopefully even afterwards, if we can use virtual technologies to honor those values more fully, we should. I think the federal judiciary ought to do that. And that is really why I've gotten so interested in this issue, because I think this is not necessarily consistent with the institutional conservatism of the federal courts, but I think there's a tremendous opportunity here. The one caveat I have really is in the area of procedural justice, and the data that we have so far is interesting. As Chief Justice McCormick pointed out, in some of the proceedings in the state courts, people actually are happier to appear virtually. They don't have to take a day off of work. They don't have to travel. They can. The default rates in debt collection cases and evictions and things like that have gone down enormously because of the availability of virtual proceedings. So that's a good thing. The federal courts don't do a lot of those kinds of cases except in bankruptcy. And the bankruptcy judges that I've spoken with are actually quite receptive to ways to expand virtual proceedings for many of the same reasons, particularly individual bankruptcies. So I think sometimes virtual technology can help us. I think we need to be careful, and that's why I say this is not a one-size-fits-all situation. There are proceedings where I think honoring the values of Rule 1 requires some type of more somber, more solemn type of situation, and sentencing has come to mind. I think there may be constitutional limits when we talk about confrontation in criminal cases. But essentially, Mr. Chairman, I think there's a tremendous potential here for using modern technology to better implement Rule 1.
Thank you. Chief Justice McCormick, would you respond to the same question?
Yeah, thank you very much. There are hard questions I think I agree with everything Judge Fogel said, so let me start there. And there are definitely areas where there are conflicting values that we're going to have to spend some time thinking about, talking about with stakeholders and figuring out our way through. Judge Fogel is absolutely correct that there are some proceedings for which remote platforms will not be appropriate. My court just issued a unanimous opinion this week holding that a witness's testimony in a criminal trial by Skype violated the defendant's Sixth Amendment right to confrontation. So there will be proceedings that are not appropriate for remote platforms. But as everybody knows, a lot of what we do, especially in state courts, are not jury trials or criminal jury trials. The high volume dockets, especially the ones that we're going to see a lot of in the coming months because of backlogs, like evictions and debt collection cases, and other district court, district court cases, will be not only appropriate for remote platforms, but will increase participation. Judge Fogel is correct that we have seen in jurisdictions that are using remote platforms in these high volume dockets much higher rates of participation, which obviously enhances the first order values that you're asking about. How we proceed in those more difficult cases is something we're going to all have to think about and work through. We want to be able to give people options, because even if a litigant has a right to insist on in-person participation, there will be some that are interested in waiving that. So what we're working on in Michigan is best practices to give people options. We have just finished a jury trial by Zoom that was not it was a hypothetical jury trial. We had real lawyers and a real judge acting in those roles, but we had a member of our staff playing the criminal defendant. We had volunteers, family members and law students play the jurors. And we did it so we could develop best practices for the litigants who are interested in proceeding that way, rather than waiting until they can do it safely. There is a lot to figure out, but I want to come back to where I started, which is it is a tremendous opportunity for us to figure out how we can do a lot of what we do better, more transparently, and with more accessibility.
Thank you. My time has expired, and I now call upon my colleague, Congresswoman Roby, for 5 minutes.
Again, thank you all to our witnesses for being with us today. Judge Campbell, during the pandemic, there's been an increase in technology, use of technology that we've discussed here today by federal courts and the general public alike. However, there are valid security concerns surrounding the use of technology platforms such as Zoom. Judge Campbell, if you will, tell the committee, how have federal courts and the Judicial Conference worked to address those security concerns?
Thank you, Congresswoman. There has been a significant increase in the use of video and audio technology during the pandemic. And I agree with Judge Fogel and Chief Justice McCormick that it is a very valuable learning experience. In fact, it was the federal courts that went to Congress and asked for the ability to use audio and video proceedings in criminal cases where it wasn't authorized under the existing rules. There has been concern about the security of video conferencing platforms. Technical experts at the administrative office of the courts have worked with IT specialists in each of the individual district and circuit courts. They have vetted different video platforms for security, for the ability of outsiders to hack or disrupt proceedings. And the administrative office has made recommendations to local courts as to which kinds of video platforms were the most secure and ought to be preferred in those proceedings. And I think the courts have been using those. I think the technology platforms are improving as the pandemic goes on, but we have been very conscious of security, and the technology experts within the federal courts have been quite active in ensuring that the tools that are used are secure.
And so while the COVID-19 pandemic may have necessitated the use of technology in some instances, some commentators and there's been arguments made here today that both the federal and state courts alike should be using technology in the courtroom even after the pandemic passes. However, as I mentioned in my opening statement and has again been brought up since then, not every jurisdiction may be equipped to administer remote technology. Again, I've already mentioned this, but some jurisdictions may have unreliable internet connection or poor access to quality broadband. And so, Judge Campbell, I'm going to give you an opportunity as well to weigh in on this issue.
Just a few thoughts in response to that, Congresswoman. We have heard of and are aware of the fact that there are jurisdictions where the ability to connect to the necessary locations has been limited by technology. We have heard that that's particularly true where federal detainees are housed in local jail facilities or detention facilities that have not had video conferencing capability or have had limited telephone capability. And the courts have worked with those facilities so that the video and teleconferencing proceedings in criminal cases could go forward. Progress has been made, but there are still clear limitations by matters external to the court, such as the availability of broadband or the funding of a local facility where individuals are housed. I will note that I understand an important part of this proceeding focuses on civil cases. And before the pandemic arrived, federal judges were using technology in civil cases relatively frequently to conduct hearings for case management, for oral arguments. It's a very common thing in my court for participants to call into proceedings if they're from out of town. And a lot of pretrial work in the civil side was already done by technology. Obviously, we're doing a lot more of it now, and I agree with the points made by the speakers already that there is much we can learn from the experience we are having in the pandemic.
And I would just say, you know, given all of these limitations, we've got to ensure that courtrooms are ready to reopen for those who may not be able to participate in remote judicial proceedings. So if you want to weigh in on that as well.
I agree with that. And the question of how to reopen courtrooms and how to conduct proceedings carefully is a very difficult one, a critical one. Every district court in the United States is investigating and developing policies for how you bring in 60 people for jury selection, how you then seat a 12 or 14 person criminal jury that will be together for 2 weeks, and how in that process you keep the jurors safe, how you socially distance, how you limit exposure to a lot of things in trial that would normally be presenting health risks. Who do you screen at the front? How do you determine or set criteria for who is allowed into the courthouse? All of those issues are being explored. Policies are being developed. We want to reopen the courtrooms as soon as possible, consistent with public health, and courts are working on the basis of their local circumstances to develop those policies.
I've gone over my time, Mr. Chairman. I appreciate that. I would just ask that this subcommittee be kept informed every step of the way about what this looks like. Obviously, it's important for us to know the things that the judiciary is putting into place as it relates to best practices moving forward, and understanding the urgency as well as these cases continue to backlog. So thank you, Mr. Chairman, for letting me go over. I yield back.
Thank you. Next, the gentleman from Arizona, Mr. Stanton, for 5 minutes.
Thank you so much, Mr. Chairman, for hosting this critically important hearing, and thank for the outstanding witnesses for being with us here today. COVID-19 has presented challenging hardships to our federal court operations. Maintaining fair and equitable access to our justice system continues to be of utmost importance, and I commend the judiciary for being innovative in its response. However, we must be vigilant that the courts are considering how its adaptations are affecting underserved communities. One of these critically important communities is people living in Indian country. My home state of Arizona is fortunate to have a significant Native American presence with 21 tribal nations in our state. Sadly, COVID-19 has hit these communities hard. For example, the Navajo Nation has one of the highest per capita rates in the country, which has resulted in curfews and lockdowns. With a high infection rate coupled with a limited internet access and vast rural areas, I am concerned that people living in Indian country are experiencing unique difficulties in accessing the federal courts. Given the significant presence in Indian country, the significant federal presence in Indian country, I want to ask specifically how judicial system is accounting for challenges present there. I want to ensure that their needs are thoughtfully, thoroughly, and equitably addressed. I have a question for Judge Campbell. You have been a judge in Arizona for nearly 2 decades and have presided over a variety of areas. We are fortunate that someone with your experience and expertise serves on the Committee on Rules of Practice and Procedure. And I noticed that both the Committee on Federal Judiciary COVID-19 Task Force have representatives from important stakeholders. Do you know if the Federal Judiciary COVID-19 Task Force or the Committee on Rules of Practice and Procedure have tribal representation?
Thank you, Congressman Stanton, and thank you for your support of the courts in Arizona. There is not, to my knowledge, tribal representation on the committees within the federal judiciary that oversee the rules of practice and procedure. Those committees consist of federal judges, academics, and practicing lawyers who are appointed for a term of years to work on the committees. And I'm not aware of a Native American who is present on those committees. Consists of chief district judges, court unit executives, a representative of the federal public defenders, a representative of the U.S. Attorney's Office, a representative of the U.S. Marshals, and the General Services Administration. I know that that task force has reached out and sought input from courts around the country on issues that they are dealing with. As you know, Congressman Stanton, our chief judge in Arizona, Chief Judge Murray Snow, is very conscious of the needs of Indian country. He has been communicating with the administrative office about those needs. He has developed some innovations for the federal courts to reach out to Indian country, including holding jury trials on the Navajo reservation, which has happened under his leadership. And of course, we have as a member of our court, a federal district judge, Diane Humitua, who is a member of the Hopi tribe and brings that unique perspective to our court and to the federal courts generally. So my hope is that the courts that deal with Native American populations will be active, as I believe ours is, in helping the federal court system understand those needs and serve them better.
Thank you for that answer, and I do agree that Judge Snow is very concerned about those issues. I would ask that you would consider advocating for adding a tribal representative to both the task force and the committee. I think that the communities, our country, would be better served if that was the case, particularly for the unique role that federal courts play in Indian country and Arizona around the country. And then one final question for Judge Campbell or anyone else. What work is being done to ensure Native American representation on juries, particularly those that originate in Indian country?
Well, I can respond to that briefly, Congressman. In Arizona, when we hold jury trials in criminal cases or civil cases, we divide the state into 3 different jury districts. We have a Northern Arizona jury district that encompasses the Navajo reservation and a number of other Native American lands. And when an event occurs in Northern Arizona, whether it's a civil or a criminal matter, the jury is drawn from that Northern Arizona area specifically for the purpose of including everybody within those areas, including Native Americans. And so it is typical when we have cases that arise in Northern Arizona, we will have Native American members of the jury. I think there is a need to increase their participation, to reach out to those communities and encourage their participation. And that is something that Chief Judge Snow is doing quite actively, and Judge Humitua is also.
All right, thank you. I'm out of time, so I will yield back. Thank you, Mr. Chair.
Thank you. Gentleman from Virginia, Mr. Klein, is recognized for 5 minutes.
Thank you, Mr. Chairman. The COVID-19 crisis has caused many of us to change the way we perform everyday duties, whether it's teleworking, Zoom calls, or wearing masks in public settings, or ordering everyday essentials online. Our way of life has changed drastically in just a few short months. For our judiciary system, the challenges that these changes have caused have been monumental, with federal and state courts grappling with how to best continue their essential operations while keeping everyone involved safe. It's my understanding that the Administrative Office of U.S. Courts has sought to assist federal circuit courts in their response to the crisis by issuing guidance and acting as a repository of information. And for that, I'm very grateful for the leadership role that the AO has undertaken. Although many federal and state courts have closed courthouses and stopped court proceedings, we must remain mindful of the rights of those who come before our court system seeking justice. One of the ways that we in Congress have sought to support our court system during this time is through passage of the CARES Act, which permits the federal judiciary to conduct criminal proceedings via audio or video conference, subject to certain constraints. For example, if the judicial conference finds that the COVID-19 emergency will materially affect the functioning of federal courts, the chief judges of federal district courts may authorize the use of video teleconferencing or telephone conferencing if video teleconferencing is not reasonably available for criminal proceedings in certain instances. So to assist with these changes, the CARES Act appropriated a total of $7.5 million to the federal judiciary to address immediate information technology needs and increase testing and treatment costs for the pretrial and probation programs. $500,000 to the Supreme Court, $1 million to Defender Services, $6 million to federal courts and other judicial services to prepare for, and respond to coronavirus. While I support transparency in our government, I do remain concerned about the impact that cameras in the courtroom could have on proceedings. However, as an advocate of same-day audio, I was thrilled to see the Supreme Court allow for real-time audio of their oral arguments this session. This is a worthy reform to our federal judiciary, and I hope that it will remain in place long after the coronavirus crisis ends. Thank the witnesses for their time today to discuss the challenges that the coronavirus has caused. And I would like to ask Judge Campbell, due to the pandemic, many courts have had to suspend or stop jury trials in light of pressing health concerns. It's my understanding that the Judicial Task Force for COVID-19 convened a working group to consider how grand juries and juries may safely reconvene as courts reopen. What are some of the most important considerations for courts to consider as they restart grand jury and jury trials?
Thank you, Congressman. The subgroup of the AO task force that you mentioned produced a booklet, 10 or 12 single-space pages of recommendations on the kinds of steps that courts can take to ensure the health and safety of jurors when they return to the courtroom. It's really very detailed. In fact, I reviewed it carefully because I had a jury trial scheduled to start next Monday, but we have postponed it in light of the rising infection rates in Arizona. But it's a very detailed description of the measures that should be taken to ensure that jurors aren't infected when they come for jury service, even down to detail of how many people should be in an elevator, where you should put markings on the floor for jurors to stand, where you should put markings on the bench in the courtroom for jurors to be 6 feet apart, the use of plexiglass screens. It's a very detailed document. Equally important, I believe, is that federal courts and state courts as well be able to assure jurors that when they come to court, their health will be protected. And so every federal court has been directed to prepare a public notice. Ours is about a page and a half that sets forth in detail the steps we will take to ensure the juror's safety when they come to our courthouse. And that goes out with every jury summons so that jurors know we are taking those steps and hopefully can ensure their safety when they come. There have been 2 jury trials held recently, one in the Northern District of Texas and one in the Eastern District of Texas. They were held last week. The procedures followed, the precautions taken have been shared with the federal courts generally, and we will continue to watch and learn as we go through the process of resuming jury trials.
Thank you, Mr. Chairman. I yield back.
Thank you. I'll now recognize the gentleman from California, Mr. Correa, for 5 minutes.
Thank you, Mr. Chairman, for holding this most important hearing. As I listen to our witnesses, and again, thank you very much for being here today. As I listen to your testimony, I'm reminded of that saying that justice denied by delaying justice. I'm also thinking back to my experience in government, which is government usually manages by crisis. It's very difficult for government to manage beyond the next day. I'm also thinking about 911. We never really went back to being the same after 911. And as I think about COVID-19, I suspect and I hope that we will not go back to business as usual after COVID-19. With that being said, as I think about your operation today, essentially assuring that our court systems work well, assuring that we have due process, we talk about a study, we talk about studying what we're doing today, yet I don't think your branch of government has the luxury of time to study the issue. I think right now, I suspect that right now, your local courts at all levels are managing this crisis by adopting, by changing. And so I would say that we don't have the time to study the issue. Our libraries are full of studies that after those studies are concluded, they're just put away and move on to the next crisis. So I would ask all of you, could you begin to give us a list of those best practices that are being implemented right now that will change for the better the way our court system actually operates? And Ms. Wasser, I want to say that I was very delighted to hear that public participation, public interest in the judiciary system has actually gone up. If there's a silver lining in this crisis, it is that people are watching proceedings today online. And Chief Justice McCormick, you mentioned the word dentists, which brought back some very negative emotions to my psyche. And I'm thinking to myself, probably most Americans would look at a courtroom the same way. I don't want to go do jury duty. I don't want to go near that building, just like you would with a dentist. So again, I ask all of you in general, what are the best practices that you're implementing right now that we could advance on, that could be permanent to make sure we better the way courts operate in the United States? Open it up for answer.
May I?
Yes.
This is Judge Fogel, and Congressman, I think that's an excellent question. And my answer to your question about study, because I think I was probably the person who emphasized that the most, is not something that would be done over years of time and sit on a shelf. I think you're quite right that there's urgency here. But I think one of the real assets that the federal courts have is they have resources to look carefully at what they're doing and produce exactly the type of list of best practices that you're asking for. I don't think it can be done on the fly, but I think it can be done relatively soon through the type of applied research that the federal courts are very good at. In fact, the agency that I had the privilege of directing for 7 years, the Federal Judicial Center, that's what it does. That's its one of its two major missions. One of them is education for judges and court management, and the other is applied research. And I think with working with the committees and the task forces, with Judge Campbell, the task force, the rest of the Judicial Conference, that's exactly the type of reflective product that could come out. And I think it could come out in a matter of months rather than a matter of years. And I think it's exactly the type of guidance that we need. What have we learned? What are the best practices? What should we keep? What should we stop doing? You're asking exactly the right questions. And I think the good news is that the federal courts actually have an ability to do that type of applied research. So that's what I would say.
Let me jump in as well. I also appreciate the question, and it is an excellent question. And I agree with you that a lot of people view courts like dentist's office. They're not usually looking forward to going there. I always say, usually when people are in court, something traumatic and stressful is happening in their lives. Not always. We do have adoptions. Sometimes people need to get married in courts. That can be fun. But usually something traumatic and stressful is happening. And so how the courts treat people, going back to my opening, is the whole ballgame. I always say, we're kind of selling trust in government. How we treat the 3 million different, the 6 million people who need their cases resolved in our courts every year, gives us an opportunity to really grow faith in government or erode it, depending on what we do. And so the best practices that we're learning right now, we actually are immediately putting out there. Let me refer you to the National Center for State Courts post-pandemic, it's got a big long name, Rapid Response Technology Innovation Committee. I don't even know if that's the right name, but I co-chair it with the talented court administrator from the state of Texas, David Slayton. And we have already produced a series of best practices, best technologies, and put it out there for state courts across the country. And we meet weekly in 3 subcommittees to update it. So we are actually doing exactly what you think we should be doing. I want to I want you to know. We are also doing it in a way that is not necessarily perfectly comfortable for judges and lawyers. I always say we were trained to move slowly. We are small c conservative for lots of normative, cultural, and important reasons, frankly. And yet, we are right now having to act like entrepreneurs. And it is for the benefit of the people of the country who need to use our courts to resolve really important disputes in their lives, often without lawyers. So the transparency we're seeing from remote proceedings, the accessibility we're seeing from remote proceedings, and the way in which people feel less intimidated and more able to participate are easy answers to your questions. But I think the harder answer is we have to continue to be capturing those best practices and sharing them widely. Thank you for the question. We're working on it.
Mr. Chairman, I'm out of time.
Thank you. We will embark upon a second round of questions, and I will begin by asking Ms. Wasser that you note in your testimony that courts have taken different approaches to adopting the Judicial Conference's guidance on providing access to the public and the media. What issues have members of the press run into under this disparate court-by-court approach?
Sure, thank you, Chairman, for the question. So at the beginning of the COVID-19 pandemic, we were seeing some disparities with reporters noting how they could receive public notice of remote proceedings, whether that be a link sent to posted on their website, which would be the most publicly accessible, or trying to figure out how, outside of being noted on a pacer on the docket, to call into these proceedings. There were some instances where in the federal, I believe it was at the district court level, there was remote access made available for the attorneys and the litigants, but not a members of the public line, or not a press access line. I would say also in response to Representative Correa's question, this would be, for a best practices standpoint, an opportunity to make notice more widely available. This is something as easy as posting a link on the front of a court website to make sure that members of the public and members of the press are able to access it, and that would also help increase public participation. Also seeing this as a possible opportunity for long-term investment. Congress has an opportunity here to provide support and guidance through funding, maybe through the appropriations process, to allow all levels of the federal courts to broadcast and live stream their proceedings while also making notice more widely available. I would note Ranking Member Roby's concern about her district and the lack of access to broadband, and I appreciate and I understand that concern. A potential fix there would be the ability to, if they can't stream video or even stream audio without the access to broadband, that they provide a dial-in number, giving members of the press and the public the opportunity to be able to access the proceeding during remote times. And as courthouses start to reopen, this would help prevent someone who is asymptomatic from coming into the courtroom, but still being able to access the proceeding at home. And so I think there are real opportunities here to move forward, especially on the notice front. I would also mention, I know a couple people have mentioned studies. We can look and see what the courts are doing now. All of the circuit courts, except the Sixth Circuit, have live audio available as of yesterday. So moving forward, we can see what has worked with live audio and start to take incremental steps from there.
Yes, thank you. We're only limited by the imagination of the judicial branch in terms of its requests for funding for any particular programs that it may deem appropriate for the judicial branch. We're only limited in terms of that imagination. Ms. Wasser and Chief Justice McCormick, if you would address this issue, what message to the public would the Supreme Court send if it decided to stop broadcasting its proceedings? What message would the court send if it expanded public access by allowing live video, not just audio, of its proceedings? If I might impose upon you, Chief Justice McCormick.
Yeah, thank you for that question. I am on record as being in favor of live streaming proceedings at the Supreme Court, as well as in the courts of appeals. My court, the Michigan Supreme Court, has been live streaming our proceedings for many years, from long before I joined it in 2012. The reason we do it is because Michigan is a big state, and people who live far away from Lansing but are citizens of our state have, in our view, the right to see what their court is doing and how they're doing it. It feels to me like it builds trust and confidence in our branch, which, as I said, is the only currency we have. And so transparency is the way to build that. And I think it only increases the confidence in the court's work. 100% of the time, 50% of the people don't like our decisions. We usually end up disappointing everybody by the end of a term. But if they believe that we are operating fairly, that we're listening, that we're treating everybody with dignity and respect, they will have faith in our outcomes, whether it's their favorite outcome or not. And that is the big benefit of transparency. I will say that some of the cases we hear in live stream, I think the only person watching is my dad, and he just wants to see me. He lives in North Carolina. So they don't all have the same amount of public interest, but they should all have the same accessibility to everybody who lives in our state, and frankly, everybody who lives anywhere. As I said, I believe it builds trust and confidence in the work the courts do, and that is the whole ballgame.
Thank you, Ms. Wasser, if you would respond.
Yes, thank you, Chairman. I would echo the sentiments of the Chief Justice. I think the Supreme Court, if they do decide to extend a video or even live audio access, it promotes a message of transparency. It helps extend the gains of transparency that have been made due to the situation of this pandemic. Increasing public access is something that's extremely important to help promote accountability and promote transparency. I think they also send a message of strengthening our democracy. As the Chief Justice mentioned, being able to view these proceedings or listen to them via audio would send a strong message that the public does have an interest in what the court is doing. We have seen in the past that justices have repeatedly said there's no demand for this, or they don't believe that people would really understand this part of the process with oral argument. And what we've seen from the 10 oral arguments being live streamed in May was that that simply isn't true. People want this access. They want to know what the nation's highest court is doing, and it helps better inform their decisions moving forward in how they decide to trust and build confidence in the judiciary. I think it's very important moving forward that they continue to extend this access. I believe they've also made comments about lawyers potentially grandstanding, that's why they didn't even want audio. And in my home state of Ohio, I know the Ohio Supreme Court has been also live streaming and broadcasting their oral arguments. And I believe it only happened once in 15 years that a lawyer has grandstanded to the camera, and the justices told him to stop, and they haven't had a problem since. And we can look back on the audio files of those 10 cases in May that there was no grandstanding. There were just people talking through these cases. It was easy to understand for the American public, and it really builds trust in the federal judiciary.
Thank you. I'll now recognize the gentle lady from Alabama for her questions.
Again, thank you all for your testimony here today and your willingness to answer our questions. Judge Campbell, the Judicial Conference of the United States submitted a letter to members of Congress on April 28th of this year with a long list of legislative proposals in response to COVID-19. One very specifically submitted by the Judicial Conference is to convert temporary judgeships into permanent judgeships. So can you briefly discuss this proposal and describe how it would help the federal judiciary respond to the ramifications of the pandemic? And Mr. Chairman, I'll just note this is already part of the record because it's part of Judge Campbell's testimony.
Yes, thank you, Congresswoman. There are two parts to that request that have been made. One part focuses on bankruptcy courts. We are expecting that there will be a surge in bankruptcy filings because of the unfortunate economic outfall of the pandemic. There are 14 temporary bankruptcy positions that are identified by the courts, and we request that those be made permanent positions that will allow additional and permanent judicial resources in those districts where they are needed. There are also temporary federal judgeships, some of which have been temporary for a long time. One in my district has been temporary for 17 years. And those typically are extended 1 year at a time, and the courts don't know whether they will be extended or not. And if they are not extended and the judge retires, then the position is not filled. So even courts with burgeoning and demanding dockets face the prospect of actually losing judges if a temporary judgeship isn't extended. So that's why we have asked that in these areas of great need, districts that are very busy and bankruptcy courts that are going to be very busy, the Congress make permanent these judgeships, which currently are only temporary.
I appreciate that. And there's other legislative proposals in this letter, so I just want to give you an opportunity if there's something that you would like to highlight for us in the time I have remaining. But again, thank you very much for your testimony, all of you here today. Judge Campbell.
Thank you. I don't think that I will attempt to identify any particular of the 17 proposals. There are a wide range of issues that are addressed. They have all been developed in consultation with courts around the country. A number of them affect federal public defenders and their needs, which are obviously critical during the time of pandemic. So I would simply request that you please review and consider all of them. The conference considers them all important. I would like to add one point in response to what Congressman Correa asked a few minutes ago about best practices. I mentioned that there is a location on the federal court's intranet where courts can go for information, and one of the categories of information on that intranet are court orders and local practices, best practices in effect. And if a judge goes there or a district goes there on the intranet, the judge can find literally hundreds of orders from courts around the country that reflect the best practices. And the administrative office is also trying to synthesize information from courts and get those out. So there is a very conscious effort to learn from each other and to learn from the state courts as we go through this unique time.
Thank you. And Mr. Chairman, I yield back.
Thank you. I now recognize the gentleman for Virginia for 5 minutes.
Mr. Chairman, I just want to thank the witnesses for participating. I don't have any further questions at this time. I'll yield back.
Thank you. Gentleman from California is now recognized.
Thank you, Mr. Chairman. I first of all wanted to clarify, we talk about access to the courts, and Chief Justice McCormick, you mentioned being on the record to supporting video live streaming of your courtroom in the appeal courts. What about the lower courts? So do you feel the same way about having those live streamed?
I do, which is not to say that there should not be exceptions. There are exceptions right now in public courtrooms for when we are when we do not provide access. You can what those are. Protecting witnesses who need protection is something we have a sophisticated process for doing in our courtrooms throughout the country, and we can do it in our virtual courtrooms as well, and we should. But for routine matters, live streaming processes in courtrooms, including trial courtrooms, should be the norm. Again, it builds confidence. In Michigan, you can go on the Michigan Supreme Court website, you can click on the virtual courtroom directory, you can then click on any county in the state, see which courts are operating, and then click on the live feed, which is a YouTube feed, and watch those courts operate. The press can do it, the public can do it, family members of litigants who are immunocompromised and can't make it to court can do it. It is, in my view, really important to building confidence in the work that this branch does. And like I said, I believe when we build confidence in our work, we are really building trust in government.
Totally agreed. Judge Campbell, the same question to you. Any thoughts about local courts having those proceedings online and viewed by the public?
Okay, does that work?
Yes.
All right, thank you, Congressman. As you know, it has been the policy of the Judicial Conference since the mid-1990s not to live broadcast district court proceedings. And there's actually a federal rule of criminal procedure that addresses that as well. The policy of the Judicial Conference has been to allow courts of appeals to make decisions on what they will live stream. And as Ms. Wasser indicated a few minutes ago, many of them do that as a routine basis, and most of them are doing it now during the pandemic. That has been the policy and remains the policy of the Judicial Conference. I think it's also absolutely true, though, that we are learning from the pandemic. Judges are doing more video and teleconferencing proceedings. I agree with Judge Fogel. There is much to be learned from that process. But the policy that exists now is not to allow broadcasting from trial courts.
Same question to you, Judge Fogel.
If you'll unmute.
Thank you. Thank you very much, Congressman Correa. I was a district judge for 20 years, and before that, I was on the state court in California, where the default was the opposite, where everything was presumed to be open and capable of being transmitted. And frankly, I think I agree, particularly on reflection, having been out of the judiciary for a couple of years, with what Chief Justice McCormick said. I think there are situations where you have to be careful. Privacy, cooperating witnesses, things like that, where it's just not appropriate. But in general, I think sunshine's a good thing. And I think the federal courts have been forced to do something which is outside their comfort zone as a result of COVID. And I think that's exactly the type of thing that they should take the opportunity to think about again. And the outcome, of course, is up to the Judicial Conference, and it's up to them to decide what policy they think makes sense. But now we have some actual data as to what has occurred when these proceedings have been open. And I think it is something that ought to be looked at, reflected upon, and thought about in terms of what we do going forward.
Ms. Wasser, the same question.
Sure. Thank you, Congressman. I would echo the sentiments made by my fellow witnesses. There should be a presumption of openness here. I agree with the other witnesses that there would be some situations in which district courts would need to take into consideration privacy of witnesses. District courts could also keep broadcast restrictions in place to stop the rebroadcasting of video access. But I would note that there was a pilot program put forward by the Judicial Conference in 14 district courts over 4 years, I believe in 2011 to 2015. And the results of those show that, a lot of the participating judges and attorneys actually favored court proceedings, more than 70% in fact. And at the end of that pilot program, more judges were in support of cameras in the courtroom than against. And most judges and attorneys said they would be in favor of permitting video recordings of civil proceedings. We note that in our written testimony that we submitted. Another thing to note at the district court level with that pilot program was that many judges and attorneys were actually quite surprised that cameras were as unobtrusive as they were. And so moving forward, I don't see any problem with increasing access at the district court level, although I would ask that Congress provide that support and guidance to the Judicial Conference and work with the Judicial Conference to possibly amend the cameras in the courtroom policy, because as other witnesses have mentioned and you, Representative, have mentioned, we are not going back to our old normal, and this is the new normal. Sunlight is the best disinfectant, and regardless of whether there's a pandemic or not, we would advocate that you do what's most accessible for the American people.
Thank you very much. Thank the witnesses, and Mr. Chairman, I yield.
Thank you. Chair will now recognize the gentleman from Ohio, Mr. Shabbat, for 5 minutes.
I thank the chairman, and I want to thank the witnesses for being with us, if not in person, at least through this procedure today. While this hearing is focused on how federal courts have handled their work during the pandemic that's kept most at home, it provides a great opportunity to raise the importance of allowing cameras in courtrooms to maintain or improve public access to court proceedings. Earlier in my tenure as a member of Congress and a member of this committee, I introduced legislation, the Sunshine in the Courtroom Act, and in fact, I believe along with now Senator Chuck Schumer on this committee, we introduced it together, and we've introduced it with other members over the years. And it would have allowed federal judges to permit audio and visual coverage of court proceedings in all federal courtrooms at the discretion of the judge. If a judge didn't want to do it, then it didn't have to happen. But overall, it would be available. In this Congress, Chairman Nadler and I introduced H.R. 5645, the Eyes on the Courtroom Act. This important legislation will require that cameras be allowed in all Supreme Court and federal appellate court proceedings unless a presiding judge determined that permitting cameras would violate the due process rights of a party or would otherwise not be in the interest of justice. We as members of Congress have our proceedings televised on C-SPAN, for example, streamed on YouTube and on each committee website. In fact, this very subcommittee hearing today is being streamed right now. Most of our official actions can be reviewed by anyone, including by judges. In my opinion, the same should be true of our federal judiciary. While all of our activities are recorded and preserved for review by the public, federal judges who judge our decisions largely do so in private. And that's despite the fact that nearly all the states, including my state of Ohio, allow cameras in their courtrooms without incident or spectacle, although there were lots of predictions early on of all the terrible things that would happen, and for the most part, they have not happened. As such, I think the federal courts should be brought into the modern world as well. An informed citizenry is essential to our constitutional system of checks and balances, and I think the American people deserve an opportunity to see how our court system works, just as they can proceedings before this body. And I would like to ask, I think, Justice McCormick, Madam Chief Justice, I understand that for the period between April 1st and June 1st, trial courts in your state held over 35,000 meetings on Zoom, totaling more than 200,000 hours of hearing. How has that worked for those proceedings, and how have courts in Michigan worked to address security concerns, for example?
Thank you for the question, and thank you for your work on transparency in our branch. I share your concerns. I believe that when the public sees courts working, it builds confidence in what we do. Even if they don't like the particular outcome, they will understand it and respect it. And that's the whole ballgame. In Michigan, our live streaming of thousands and thousands of hours of trial court proceedings has gone extremely well. We are collecting information from litigants and lawyers and judges. There are a number of judges who have been able to keep almost current in their dockets as a result of the remote technology platform. Litigants report really appreciating the opportunities that the platform gives them to feel on equal footing, and they report being treated with dignity and respect, which we know underscores public trust in the outcomes, even when they're not their favorite outcomes. And lawyers are overwhelmingly happy with the efficiency it provides. A lawyer can appear in courtrooms in faraway places of the state all in one morning.
Thank you, Judge. I don't mean to cut you off there, but I've got about 20 seconds left. Could I just go to the other witnesses real quickly and say, would you favor this type of legislation allowing the federal courts to have cameras there? I see nodding by one, and I'm too far. Yeah.
Congressman, and speaking in my personal capacity, I would. I think trial judges are in a position to make a discretionary determination as to whether it makes sense in a particular case, but I don't think they should be precluded from doing it.
Thank you. Mr. Chairman, could the other two weigh in? Thank you. If the other two would like to weigh in, we'd welcome it.
Congressman, as you know, it is the policy of the Judicial Conference not to broadcast proceedings from trial courts, although courts of appeals do so and are permitted to. That's been the considered judgment of a very diverse group of judges on the Judicial Conference for years and remains the conference policy at this time.
Thank you. Would the final witness like to?
Absolutely, Congressman. We would welcome that legislation. We specifically do mention it in our testimony. In addition to your legislation to require cameras in the Supreme Court, we would also advocate for the 21st Century Courts Act, which is co-sponsored by the chair, requiring the live audio of the Supreme Court, not only in oral arguments, but also in opinion readings as well, and also creating a live audio archive for federal appellate proceedings, along with HR 6642, the Court Access Amid the Pandemic Act, which would require the oral arguments in federal appellate and district courts made public. We'd also ask Congress to provide guidance and support to the Judicial Conference to talk through a possible amendment to that cameras in the courtroom policy to allow broadcast or streaming in district courts.
Thank you very much. It's been said, Mr. Chairman, that sunshine is the best disinfectant, and I tend to share that point of view. And thank you for your indulgence, and I yield back.
I thank the gentleman. And with that, we will conclude today's hearing. Thank you to the panelists for your appearance today. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record, and this hearing is adjourned.